So from your point of view, that what has to be done? Is it a situation where a Secretary of State can make a decision on their own, or does it have to go to the courts, or have you not made a decision yet on in Michigan, how people are petitioning you to disqualify Trump via Section 3 of the 14th Amendment? What should be the result?
Well, there's sort of an open question first about who is the right entity to determine this question. And ultimately, it's something that the U.S. Supreme Court will need to solidify for the country. I think the U.S. Supreme Court is the appropriate institution to provide that resolution. And I think it'd be better for the country if that resolution came sooner rather than later. To me, in Michigan, as a witness personally to the actual attempts to nullify the will of the voters in our state, I think the arguments for disqualification are quite strong, but there are also counter arguments on the other side that are important, that raise important questions, like, what is, particularly if a determination is made without a criminal conviction, how do we ensure proper due process? How do we define insurrection or rebellion? How do we define giving aid and comfort? And who exactly makes that determination? And then there are evidentiary and fact questions as well, some of which will be examined and determined by courts in the ongoing criminal cases in the months ahead. So all of that is unfolding. And in all of those cases, a state official has a responsibility to follow the law and the Constitution, which is my North Star in this moment. But at the same time, a lot of those important legal questions and definitions and facts and evidentiary findings need to happen in the legal system. And that's, I think, ultimately what we will see play out, not just in our state, but in other states in the months ahead.
For the record, I have volunteered to define what an insurrection is just to help out the situation, but they're not allowing me. Although I will say there was the case in New Mexico with the head of Cowboys for Trump, and I wrote about that for MSNBC. It was a really well-reasoned opinion. And I read the opinion like a couple more times over the weekend. And historians testify what an insurrection is: an assemblage of people to stop the execution of a federal law using violence or force. And that's why the judge found it. Now, it's also used a really unique way of getting the guy out of court, this weird, like, waranto, something. I'm like, what is that? And it's something when you disqualify someone who's in office already, saying it's not winning or losing, they're disqualified. But when you look at it, I mean, if someone were to be nominated for president and they were clearly 32 years old, could they be, and the Constitution is 35, as Secretary of State, would you say, well, that's who the party nominated, it goes on the ballot, and then people have to file a lawsuit to challenge it? Or would you, as Secretary of State, go, well, no, that clearly violates the Constitution, we can't put them on the ballot?
Yeah, so here's the question: how, and this came up with a birth certificate as well, if someone is where someone is born, who makes that factual determination? And does the Secretary of State have the power under the law to make that factual determination, whether it's age or place of birth or another fact? And then when is the right time to make that determination? Is it prior to getting on the ballot? Is it after there's been a complaint filed? Perhaps someone's qualified to be on the ballot and then a complaint is filed, or is it after the election? So a lot of those are unresolved issues because in many, or I should say in some states, those issues have been resolved in a way that says the Secretary of State doesn't have necessarily the discretionary authority to make a decision on qualification unless someone else brings up evidence to suggest that that lack of qualification. In other states, when you sign your affidavit to be a candidate, you have to attest that you are of the right age and otherwise qualified to serve in that particular role. And so there's various different paths to getting on the ballot, and there's various different paths and decision points for disqualification. And we're in a moment for this where there's a universal case, meaning this is someone who will be running in every state for a national election, in which every state and many states have different paths to making those decisions. So all that to say is it's quite complex, and one should argue it should be. But my hope is that it's, why again, I think we'll see the U.S. Supreme Court ultimately making a determination on this particular set of facts and circumstances that will provide guidance and clarity to election officials around the country.
If somebody lived in Michigan now and they're a registered voter under the law, and I ask you, not only Secretary of State, you're the former Dean of Wayne State University Law School, a very good law school, and would a voter in Michigan have standing to bring a lawsuit to challenge the qualifications of a candidate?
That is also an open question at this moment. And not only that, but does a candidate, the U.S. Supreme Court is going to be in the next few weeks looking at that question. Can another candidate challenge that as well? And so the whole issue of standing even is being resolved in various, and will be resolved through the courts as we go through this process. I mean, ultimately, the states, and we recognize this, are likely to be sued either way, either by supporters of a candidate who's left off the ballot, or a candidate's opponents if that candidate's put on the ballot. And so there's lots of also different avenues to get to the court. And in some ways, the court as the final arbiter takes away the, for lack of a better word, relevancy of a determination made by the Secretary of State, because again, a lot of this can, and I think rightfully should, be determined in the legal process.
Certainly, and it should be appealed. And I agree, like everyone else, you go to the Supreme Court of the United States, and there should be due process for whoever the candidate might be in any scenario. They shouldn't be taken off the ballot. Is there anything instructive? Because the last governor's race in your state, Michigan, some candidates were struck from the ballot, Republicans running, and had to do with the petitions that they had submitted. Is there anything instructive there? And it's not for you, because I'm not trying to pressure you to do this. You're going to do whatever's right. And I say, who was it? Voters that brought that, or was it actually like an election commission that made a determination there was not enough signatures submitted?
Yes, it was not just that there weren't enough signatures submitted. It was the State Board of Canvassers determined that there were not enough ballot signatures. And that there was, and there's still ongoing discussions about this, even, fraudulent signatures submitted, people, fraudulently signing names and not actually representing voters' signatures. So that was a little bit different, because it was a question of how one gets on the ballot and failing to do what's required, collect the number of signatures required to get on the ballot. And there's a lot more clarity in the law on that than there is on a person's qualifications and who determines those. And so it's a little different, but it's similar in that I think philosophically, to me, because this was challenging at the time, I do believe in giving voters a choice and ensuring people who want to run for office have access to that. That said, there are rules and laws in place for a reason. And if someone who wants to run for office is, for whatever reason under the law, not qualified to serve in that position, then that does have to be enforced. And then you have this open question of what's the proper way of ensuring it's enforced by the books, under the law, and not in a way that's political.
And I appreciate that. And I didn't want to make this into a law school conversation. Like, what about this hypothetical? Well, we're grasping for straws here, Secretary. We're trying to figure out ways to do the right thing, because I have to be honest. I mean, whatever's going to happen in our system is going to happen. If Donald Trump is qualified, he should be on the ballot. If he's not qualified, this is the Constitution. Like, I've had people, I wrote an article, like, this is some gimmick. I'm like, it's the 14th Amendment. It's not a gimmick. It's either going to be comported with or it's not going to be complied with, and he's off. But you did mention it's a strong case. So we'll see how it all plays out. I mean, the decision's going to be made. There's no games. I'm not trying to get you to go, it's a strong case, he's off the ballot. I understand it's going to take time. And I imagine a candidate has to at least file the requisite petitions to get on the ballot. So I don't know if you can preemptively prevent someone from filing.
No, and that's right. But interestingly, there's not a lot of clarity in the law on that piece, meaning, and there's two different pieces. There's two different elections. There's a primary process and there's the general. And so there's two different times in which a candidate would qualify to be on the ballot, and two different times in which they could potentially be removed. And that happens again also in every state. And how a primary, in some states there's a caucus in which it's the state party that decides who's the candidates. In Michigan, it's determination made not based on signatures, but on who's generally in the public record as being a candidate. The party itself usually weighs in on that, but it's not actually a very specific process. But it usually doesn't have to be, because it's usually pretty clear who's running for president and who isn't. In other states, they do have more stringent qualifications and requirements. So it's going to play out in many ways differently in every state. And you may ultimately, have a case where, some courts are saying a disqualification is appropriate and other courts are not. And that also creates a little bit of confusion that only the U.S. Supreme Court is able to really weigh in and decide. We do.
Are you concerned about, putting aside Section 314 Amendment, what you lived through and what you saw in Michigan, even you had the fraudulent electors in your state, are you concerned about what Donald Trump as the GOP nominee is going to put our nation through, and how he's going to test our institutions going forward between now and November 24th, 2024, just assuming he is the nominee?
I think this political moment that we're in, I mean, we've already lived through for years now these tests on our institutions, and we lived through them in a quite extreme way in 2020, which, you know, to go back, and as I have had to do both before the congressional committee and before different prosecutors, to relive how far and how low people were willing to go in order to block the will of the people from coming to fruition, is really extraordinary and quite striking. And I'm glad that we're starting to see accountability for that. And that's not lost on me. But what is also not lost on me is the fact that our democracy survived. We survived really some of the worst challenges we've ever experienced in as a country. We survived and democracy prevailed. And we saw challenges again in 2022 and democracy prevailed. So I know, though the storm ahead is likely to be full of bumps and bruises to our systems, we will emerge out of this, in my view, not just successfully for our democracy, but I hope healthier than before. And after 2024, my hope is that, my perhaps Pollyannish hope, but certainly hope, would be that we can collectively move beyond this divisive moment for our country and elect leaders on both sides of the aisle who recognize the importance of bringing us back together, even if we disagree politically around some things. We do have a country to unify in support of.